I am Ben Lee. I'm the Associate Director of the Communication Management Program. I occasionally teach in the undergraduate program as well. Right, so the Communication Management Program, as well as increasingly the other programs in the school, has really benefited from increasing enrollments from international students. Right, and one of your major goals and sometimes anxiety is your options after graduation. I'm very empathic about that. I came here as an international student in '95 and successfully went through the process. So it is a major point of anxiety. It's a complicated process. As I'm fond of repeating, the United States Immigration Authorities is one agency you do not want to act with. Okay, so the rules are arcane and Byzantine, meaning they're very complicated, not clear, it's open to interpretation, and this is where good legal advice is absolutely critical. And on another day, I'll tell you a story about how my wife almost lost her shot to stay here because she went with a cheap lawyer, right? And so that's also another piece of the advice. You pay for service, the quality of service that you need, right? It's not going to Walmart and picking a can off the shelves. It's complex service tailored to a specific need. Now, I will also say, to date, I have written with Eileen Chun-Fudo here, expert opinion letters for several of Annenberg's students. And to her credit, all of them has been successful. Right, so I present to you Ms. Eileen Chun-Fudo with a lot of confidence because I work closely with her, and her firm and herself has successfully guided about at least 5 that I know of international students from Annenberg, right? Now, and you know that the field of communication is not the same as the field of software engineering, for example, right? So I want you to be aware of this as you're taking the notes, okay? And so without much further ado, I give you Ms. Eileen Chun-Fudo.
Hi, everyone. Thank you, Professor Ben.
You're welcome.
It is really nice to be here tonight. Personally, I have a lot of people in my immediate family that have gone to SE, and it's nice to be here also because I do have a relationship with Annenberg through a good handful of your alums. It's about 6 to 7 alums that I've worked with over the last 5 years. And they've come to me from where you're sitting at upon graduation or looking toward graduation, wondering what's going to happen to me after I graduate and how do I make sure that I can have the best chance at staying here. So after all, you've come here to study, probably you've done some internships, or you're looking at OPT for post-graduation employment authorization. And the whole purpose is to make sure that if you want to stay here, if you desire to stay here, and you have an opportunity, that the Immigration Service is not going to shut that door on you simply because they may not understand the nature of your discipline, or they're somewhat skeptical about the bona fides or authenticity of the job offer. Okay, and I speak of these things because those are precisely the issues that I see a lot of non-science majors struggle with. As Professor Ben was mentioning, if you're a software engineer, it's fairly linear for the Immigration Service to understand that you may have studied engineering, you have an engineering degree, and you're going to work as an engineer for an engineering firm, or something of that sort. Tonight's presentation is something that I made especially for you guys with the experience that I've gained over the last years that addresses what happens when you're not in a very traditional occupation, or your major is not traditionally recognized by immigration as one leading to an H1B. So what you have in front of you, or if you picked it up, is a H1B process flow chart. This is just a handy one-page flow chart of kind of legal steps that need to be done in order to make the application. I'm going to go ahead and move into my PowerPoint. first, definitions. So we know that an H1B is a non-immigrant work visa. That means it is not a green card. It is not it is not permanent residency. Okay? It's temporary, and it is limited to normally a 6-year period. Okay? It's a temporary status. And then the bullet point here, we mentioned that a green card is a separate application that you have to make. Okay? And that green card process, often called PERM or labor certification, can take many years. For people who have a bachelor's degree only, they've waited a good 5 to 8 years for the process to make its way through the system. For people who have advanced degrees, such as yourself, you may be looking at like maybe 1.5 years to 2+ years. But during that time, you have to maintain your temporary status. And so tonight's talk is going to focus on H1Bs because it is really the most relevant visa for your needs. Other visas such as right here, the E, the L, O, R, TN, we can talk about it later, but some are specific to your nationality. TNs are held by Mexicans and Canadians. E's are investors, treaty traders, or people involved in trade occupations, or with trading companies, so to speak, rather. L's are people who have worked abroad for a company that may have a U.S. subsidiary. O's are for people who have been in their profession for at least several years in order to achieve what's known as high recognition, sustained acclaim in their field, awards, favorable press, etc. And the R is kind of an outlier out there. It's a religious worker. But in the world of non-immigrant visas, you're really looking at E, L, O, R, T, N, and then H1. So for professionals such as yourself, you're really looking at H1. So I mentioned before that the H1 is a temporary non-immigrant status limited to 6 years generally, okay? What happens is when you get your first H1, it's usually for a 3-year term. And then after that, you can extend it for another 3 years, for a total of 6 years. However, the law always has exceptions. And so you can extend beyond the 6-year maximum period if you have a green card application that's already been made on your behalf prior to the 5th year of your H1B. Meaning you have to have a green card case pending on your behalf at least 1 year before you cap out on the 6th year. Okay, so some advanced planning is really just a takeaway from that. Another thing that's important to know is that the H1B is specific to an employer. In fact, it is held by the employer. It's kind of seen as the asset or the possession of the employer because what happens with immigration and employment-based cases is the employer submits a petition on your behalf. You don't sign anything. The employer makes all the attestations, makes the request on your behalf. You're considered the beneficiary of the petition. So sometimes people say, well, gosh, if I get an employer to petition me, can I take my H1 and work for another company? The answer is no, because it's driven by the employer. It is, in a sense, owned by the employer. That H1B petition goes to the employer's behalf. However, if you wanted to change your employer, you would have to just make a whole new H1B application. And then there are quota issues that we can go through later. Spouses and children. So spouses and children of H1Bs, so if some of you are married or are going to be married soon and your spouse is a foreign national as well, they would be able to stay in the U.S. under H4 status, and those are dependents. Interestingly enough, H4s can go to school full-time or part-time. It's considered incidental to their status that they may be allowed to go ahead and study. H4s, however, can't work, but there are some proposals in Congress that would enable an H4 dependent to have work authorization. Don't rely on that just yet because talks of that have been in the works for a few years. Okay? Now, the only non-immigrant work visa holders whose spouses can work are all the E's, E1, E2, and E3. E3s are Australian nationals under a free trade agreement, and the L1, multinational manager or executive. However, it's important to remember that your spouse, let's say they're a foreign national as well, they can also pursue an H1 in their own right. Okay. One interesting thing about spouses is that if you and your spouse take turns being a dependent of the other, it used to be that if you were an H4 spouse for 4 years and then you had an H1 in your own name after the 4th year, you can only have H1B for two more years because 4 plus 2 is 6. And so the old rule was such that any time spent in any H status, including as a dependent, unable to work, would count toward a 6-year maximum. That's been lifted, so that's good news. Not that you'd want to rely on that, but conceivably, if you were an H4 spouse for 6 years and you couldn't work, but suddenly you're able to find work and your spouse hasn't gotten a green card yet, which we hope would never be the case, that it would take that long, you and your spouse could tag team and probably go up to 12 years in H4 and H1B status. Again, not a great plan, but these things kind of lift some of the pressures that you might face, just so that you know that. So the requirements of H1. Generally, you cannot be self-employed. Okay, the government views that as possibly not being a real employer and employee relationship, because H1Bs are for employees of a specific employer. If you, the employer, and you, the employer, are the same person, the government has traditionally taken the position that this cannot be actual employment, so it doesn't, by definition, fit the H1B. There are some exceptions, but they're very difficult. That presumption is very difficult to overcome. Perhaps a more fitting approach to that, if you're your own, you own your own company and you want to sponsor yourself, would be the investor visa, which is the E1 or E2. We can talk about that later. One thing you should also know is that the government filing and legal fees are generally they're covered by the employer because they're viewed as the employer's burden. It's the employer's expense to do business. So the Department of Labor has in the last 2 years actually sanctioned employers who have received reimbursement or so-called kickbacks from the applicant beneficiary to cover the legal fees and the filing fee costs. And there is a landmark case called, I think, Prince George. It's in the school district for the city of Prince George on the East Coast, where the Department of Labor's Wage and Hour Division went after the employer, and the employer had to pay a fair amount of money in back wages and interest to H1B employees who were made to cover the cost of the H1B program. From a policy standpoint, the government does this in order to protect American workers from being, from their wages becoming lowered by foreign workers coming in to work for less. And so covering for a portion of the legal fees or the government filing fees in some ways depresses your earning power, right? Because in order to get the job, you have to pay for the attorney's fees, and then so, if you're making $50,000 on paper, but your attorney's fees cost you 3 or 4, then you really only, earned 47, 46,000. So it's a wage issue. Now, the position, the types of job positions that satisfy the H1B requirements are those that are considered a specialty occupation. So what's a specialty occupation? We used to have a joke in my old law firm that the types of specialty occupations that the government has traditionally recognized are always those one-word occupations. Doctor, lawyer, architect, accountant, engineer, okay, something like that. But we live in a new world economy, things are evolving, and we're having, we're experiencing different needs, okay? Employers might need you because you have communications management degree. So are you a management person, or are you a communications or PR or an advertisement type person? It may be all of the above. And so therein lies pretty much the biggest difficulty for non-science H1B petitions. Is it doesn't fall within the traditional H1B occupation. Okay, when I say traditional, these actual occupations are written into the regulations of the law. When they crafted the law many years ago, they gave examples, and it was teachers, scientists, engineers. And not that that list is exhaustive, right? It doesn't mean that they could have listed every occupation in the world that is professional and specialized, but the government does use that as guidance. Okay, so it's up to you and your employer and your attorney to explain to the government why your job may not be similar sounding or similar looking to one of the traditional H1B occupations, but that it still satisfies the H1. So we talked about, oh, I didn't talk about this. The H1 can be a full-time position or a part-time position. You can also have more than one H1B at a time. It doesn't come up a lot, but I've seen it with, say, professors who might teach at one university Tuesday, Thursday, and another one Friday and Saturday. So for every employer that wants to hire you, again, remember it's employer specific. You would have to have more than one H1B. Could you conceivably spend your time between employer 1 and employer 2 over 40 hours a week? Yeah, you could have two 20-hour H1Bs. And a lot of people, you know, fear that, okay? And they're only because there's a credibility element to it. Like if this employer can't hire me for full time, can they really show all the other requirements for H1B? And we'll talk about how to choose an employer in a bit, but those are some considerations, especially if you end up interviewing for a company that may be in a startup phase or only really has a part-time need right now, but does have a need. Lastly, the salary must be at what we call a prevailing wage. The prevailing wage is the competitive wage that the U.S. Department of Labor defines or sets forth for a specific occupation and specific location. And what I was going to show you was is a website. FLCdatacenter.com stands for Foreign Labor Certification Center.com. And this is where the government they keep all this data on what they think are fair wages for specific metropolitan statistical areas, or general areas all over the states. So let's say you're going to get a job in LA County, and you want to get yourself a job that's related to marketing. And so the Department of Labor, in their wisdom, have already categorized for us all the different marketing type of jobs. And it's pulled in a bunch of other things like farmers and ranchers. I don't know how that works, but their search engine pulled that up when I searched for marketing, but there you see it. So let's say you get a job as an analyst for a company that wants to use you because you have communications management and some marketing background or something. So the first thing you do if you stepped into my office would be we would look at the prevailing wage. And here they are. They're in 4 levels, 1, 2, 3, and 4, 4 being the highest. Now, the government's going to want to know whether or not your employer is paying you at least the minimum prevailing wage. If your employer pays you $1 less than that, they have not met the prevailing wage for an H1B. Okay. The further up you are, you have a master's degree, you probably should really be around level 2. Okay? But that's not always the case, as I said, with companies that are in their startup phase or in their early growth stages. That's one thing, though, you need to be aware about when you step into an interview or you start negotiating for a final offer, is that you need to be aware of the prevailing wage. And before you can look up a wage, you need to probably work out the right occupational category that we picked up. Okay, so there are a bunch of different marketing majors, and there are all kinds of research analysts out there. That's something that requires probably a meeting with an attorney and yourself with your employer, or at least with the documentation from your employer, so that the attorney will be able to say, okay, so this is this type of company, you're going to be doing X, Y, Z, and it's very specific to your job offer and then the nature of the company. Okay. So most of you, how many of you guys know that there's an H1B quota and a lottery? Okay, good. So the lottery is an unfortunate reality that I think we're just going to have to keep dealing with, okay? I wanted to just review some of the cap exempt employers, meaning that you don't have to compete in a lottery. They're pretty limited, okay? The employers who could sponsor you without you having to go through the lottery process are universities and colleges. A private employer, if their employees work at a university. So let's say you're an accountant and your accounting firm sends you to work on the premises of USC each and every day, and it's for the purpose of SC's accounting, and maybe they've outsourced it to your company. That would probably apply for not having to compete in the lottery, so you'd be cap exempt. Now the final two are very, very narrow exceptions. I've only experienced probably 3 or 4 of these over my career, but if you work for either a nonprofit organization or a nonprofit research organization, you might have a chance at exempting yourself from the quota. Okay. One thing to note that is if you are one of the lucky few that is exempt from the quota, if you later on change your job to an employer that's not one of those 4, within the 4 exemptions, you do have to compete in the quota that year. Okay, so it's not totally behind you at that point. Now, there are certain employees who don't have to compete in the quota. So employee means that you've already been selected for one H1B before. So as we mentioned, H1Bs are good for up to 6 years normally. Okay, so if, let's say you got an H1 this year and you decide next year, I'm going to look into a PhD program and I'm going to go back for a year. And after your 1 year back in school, you think, I don't want to go, I don't want to finish this program. I want to go back to working. And I got selected for the H1B in 2014. It's now 2015, almost 2016. Do I have to compete in the lottery again? The answer is no. So if you've been counted once within the last 6 years for an H1B quota, that quota number is allocated to you. Okay. In some instances, let's say if you leave your employment and your employer actually tells immigration, which they're actually supposed to, that they want to withdraw the H1, then you might have issues of whether or not you still have that H1B allocated to you. At that point, I would really look at talking to an attorney. Now, the other exemption is if you have a remainder of the H1B. Oops. The remainder is kind of a term of art, but it's for people who have been on H1 for less than 6 years, left the country, and want to return on that same H1B. You can choose to come back for the remainder of whatever exists of your 6 years. Okay? But the general rule is if you've had an H1 and you've been outside of the US for more than 1 year, you kind of forego that H1, you can't go back to it. So these are the only instances where you can go back and say I've been counted within the last 6 years and I want to take up what's left of that 6-year period. Due to some free trade agreements that we have with Singapore and Chile, Singaporeans and Chileans have special H1Bs called H1B1s, and they are taken out of the quota system. There's about 5,800 Singaporean and Chilean H1Bs that can be had by nationals of Singapore and Chile. So out of 65,000 H1Bs, like I said, 6,800 are allocated for Chileans and Singaporeans. That leaves 58,200 for the regular bachelor's degree cap. You guys being master's degree students, it only applies to people who hold masters from US institutions. It doesn't count if you have a master's from abroad. You guys will be able to compete in a 20,000 quota lottery. And if there are lotteries held for both the master's and the bachelor's degree, I have good news for you that you guys will go through the master's degree lottery first. And if you don't make it in that lottery, immigration does a nice thing, and then they put you into the regular lottery for the 58,000. So you'll get 2 bites out of the apple. Now we know that the first day to file is April 1. That's because you can file an H1B petition only up to 6 months in advance of the first start date for H1. So it's October 1. So it's crazy for employers to think, gosh, I'm going to have to get a petition ready in January, February for an April 1 application, put in the application on April 1, and then if you get chosen in the lottery, and then your case gets approved, only can that employer start putting you on payroll on October 1, okay? That's just the way it is, and it's clunky, and it's not the greatest, but that's the reality. Problem with that is that H1B, the number of H1Bs and the quota system had changed in the last few years, the last, I would say, 5 to 10 years. It used to be that there were 195,000 H1Bs available, and it fluctuated over time in the last 15 or 16 years, and Congress changed it. At first, it was 110,000, then it was they increased it to 195,000, and then I think, when the economy started to turn down and people were kind of upset, maybe there was a backlash against foreign workers taking away American jobs and, that kind of hysteria, the numbers dropped drastically, and now we're down to 65,000 plus 20,000 for master's degree holders. So that's just the unfortunate reality of the lottery. One good thing to know is when you submit your application on April 1 and you are accepted into the lottery, or you make it in before they close up the filing period, you already have an H1B number associated with your case or allocated to you. Some people begin to think, oh shoot, I need to get my case approved before I can win the lottery or something. It's not like that. If you are accepted into the lottery or you get your application in before they have to hold the lottery, the government has set aside a number for you, okay? And then when your case is approved, then you become that H1B holder of that quota number. Just as a retrospect, in 2013, and just so you know, the federal fiscal year starts in October of each year. So fiscal year 2014 started last October 1 of 2013. And so fiscal year 2014 petitions were made on April 1st. Within the first 5 days, the government knew that it had more than enough applications to fill the 65,000 plus 20,000. So what happens in that case is the government is mandated by the regulations to continue accepting properly filed applications for the first 5 business days of April. And I anticipate that will probably happen this year. So April 1st falls on a Tuesday, and so the first 5 business days will end, I believe it's April 6th, or Monday after. In that year, last year, they had 124,000 petitions in total, regular and master cap, for a total of 85,000. So you can do the math. The odds weren't horrible, but they weren't great, especially if you're going to be one of the persons who wasn't chosen. This year, by hearing what other law firms are going through, it seems like people are queuing up and getting their H1Bs, ready sooner. So perhaps people are just afraid because last year's cap ran out so fast, and maybe there really isn't going to be more than 124,000 petitions this year. But the rule of thumb is get started earlier. If you can lock down that job offer sooner toward the end of the year, or within the first few weeks of January, get your H1 prepared. Okay, and then there are numbers for the other years. You'll see in 2011, the cap actually lasted until October and November. And it's just an indication, we think, of the economy becoming stronger, employers willing to sponsor these things, pay for all the costs, and jobs just being available. So timing issue, right? I said that you would apply in April, but yet you can't start working until October 1. Most of you know that if you have OPT during that time, you can stay here and work, and you would be in good, solid F1 status, okay? There is, though, an exception for people whose OPT runs out after April 1, okay? And those people we call cap gap. I didn't write it up there, but it means that if your H1 is approved before October 1st, but your OPT expired sometime after you filed it, that they will actually extend your F1 status up until September 30th, which is the day before October 1, which you magically kind of morph into an H1B worker. Okay, so the cap gap pertains to your status. The other thing that's important to know is if your OPT didn't expire until after April 1st or whenever your case was accepted by immigration, your OPT is actually extended until September 30th. That way, the government figured, you know, we won't harm the employee, won't harm the employer by having a gap in their ability to work from, you know, your OPT period throughout October 1st. And there are some instances where people are able to apply during their grace period, but their OPT has already expired. So in that case, people would only get the cap gap protection, which means they can stay here by permission, but it doesn't extend their F1 status, and it doesn't allow them to work. Okay, but that might still be of use to some people who may find it expensive or burdensome to go home and wait for the H1B to be approved and then come back in October. Okay, portability is when you already have an H1 and you want to work for another employer. Okay, it means that if you already have an H1 and you want to work for a new employer, you don't have to wait until the new employer's petition is approved. You can start working with the new employer after your H1 has been, your H1B change of employer petition has been received by the Immigration Service. Okay, there's something also called premium processing that allows the government, or that allows you or your employer to ask the government to please give you a decision within 15 calendar days. Because as you can see, the normal processing time is about 2 to 4 months on average. More than 2 months, really. 3, 4, and 5 is probably average. The complicated cases lasting more than 6 months. One thing that you should remember is you can upgrade to premium processing anytime after the case has been received. Okay, and this is the last general slide, and then we'll get into strategies. But for people who are on H1, if you get terminated, that also terminates your status. If you get terminated from employment, if you quit or they let you go, that last day of work is your last day of status. If you have the luxury of knowing that you might get let go, or there's, you know, some kind of downsizing going on at your company, you can take it up with HR or your manager to let them know that if that should be in your future, could they give you a little bit of a heads up? Because if we could manage to get another H1B petition in for you, you would be able to use that portability provision and start working with a new employer and then protect yourself from having any status gap. One interesting thing is at the end of employment, your employer is supposed to pay for your return ticket home. Okay, but if you agree to stay and you want, I know how nice, if you want to stay and go back to school or you change employers, then you know the government really doesn't enforce that, but that is part of the law, that they're supposed to pay for your return to get home. Again, it's seen as a cost of doing business. Okay, so this is kind of going into, well, gosh, what about me? And now I know what the employer has to do, but we talked about the wages, and sometimes employees or potential clients will come to me and say, oh, I'm willing to take a lower paying job. You know, I want to take an entry-level job even though I have an advanced degree. Is that okay? That gets, you know, pretty dicey in that, you know, you could be subjecting yourself to potential immigration fraud allegation or misrepresentation claim to you and your employer. So sometimes what the government makes an example of are, like in the profession of accounting. If you're willing to take a bookkeeping job rather than an accounting job, and the accounting job is the one that's H1B caliber and the bookkeeper one is not, then if you ask for an H1B and you call a bookkeeper an accountant, that can be seen by the government as misrepresentation or fraud. So you have to be careful about that, because that kind of scrutiny is built into what we call the labor condition application. The LCA is something that is certified by the Department of Labor specifically for your employer. where your employer says, I promise I'm paying them the right wage, I promise this person's an accountant, and I haven't laid off any Americans in order to hire this foreign worker, and I have an obligation to pay, etc. Okay. So what is a specialty occupation? A specialty occupation for H1Bs is defined as some sort of job that requires both theoretical and practical application of a body of specialized knowledge. Okay, again, engineering discipline, financial discipline, and then two, that the bachelor's or higher degree is necessary for entry into the occupation. That's a prerequisite. Okay. So how do we show that a degree is really a minimum prerequisite for the occupation? So the next 4 bullet points is a word by word cut and paste from the U.S. immigration law and regulations. If your employer can show that a bachelor's degree is normally required for the position, or that the employer has normally required for that a degree for that position, or perhaps that the degree is normal to the industry, or that the position is so complex or unique that it could only be performed by someone with a degree in that field, and lastly, that the duties are so highly specialized that a degree is required. It's all kind of the same words over and over again. Specialized, required, normal to the industry, could only be performed by someone with that degree. That's where, I would say that's where most of the gray area is for H1s, and especially with students who are not in science majors, is the government doesn't always understand what is a media analyst, or what is a social media, coordinator, okay, or program manager for e-commerce. What's that? Okay. Now, what I cite here is some statistics given by the U.S. Department of Labor of what they have found to be growing occupations that require a bachelor's degree. Out of 20 occupations there, only about 2 to 3 kind of fit well with a person who has a degree in business or communications. General and operations managers at the top, but just so you know, managers don't always require a degree, right? We couldn't show that that's normal for the occupation. You could be a manager of a restaurant. Do you need a degree for that? Maybe. There are hospitality programs out there. Maybe if it's a franchise business, maybe if it's, some major restaurant, but if it's just a mom and pop kind of, hole in the wall restaurant, and you're seeking an H1B for that, not necessarily. So don't be fooled by just the general names of the occupations. It's really, the whole analysis is case by case. So accountants and auditors, that's not really a communications or marketing major type of position. Elementary school teachers, no. Secondary school teachers, no. Management analysts, perhaps. What is that? You tell me. Okay, you could be a management analyst in many capacities for many different types of employers. What's going to matter is if you call yourself that, can you show all these requirements? And it depends on the nature of the business. It might depend on something special in their business plan. Might depend on the audience that they're seeking you to communicate with and run analytics on. I don't know. Those are the things that you're going to communicate to your immigration attorney, which will then be communicated to immigration for their final scrutiny. So this is just for your reference, but out of all of that, really the only useful occupations to me, it seems, would be maybe management analysts, market research analysts, and marketing specialists. And the rest don't always relate too well. There's financial managers. Cost estimators don't make sense in your field, not that I'm aware of, but I'm open to suggestions. But this is just so you know that for non-STEM majors, the government has this mindset. They have very traditional and rigid definitions of what types of occupations they think generally require a degree. And if you fall outside of that, then you are the exception to them. It is up to you to prove to them how and why you fit into a specialty occupation. So again, this is just from the USCIS government website. They actually cite 3 occupations that are typically used in the H1B program: scientists, engineers, and computer programmers. So again, what about us, right? what I've kind of experimented with and very successfully, so due to the credit of you guys really, is the Annenberg students have kind of taught me over the years what are some of the core competencies and core knowledge for jobs in your field. And I don't profess to have much knowledge on my own outside of what you tell me and what Professor Ben tells me and what employers are showing that the market requires in your skill set. But it's all open to interpretation. What I've done is to go through some of the traditional and the black and white, the black letter law, okay? It's very rigidly constructed. And it's interpreted in a narrow way. There are a lot of cases out there that are denied. One just went up to federal district court on appeal. It was a market research analyst. Okay, so the government has struggled with these types of occupations as satisfying the H1B criteria. There's just no doubt about it. I'm going to back up a little bit and go through something that you may have all heard about, the RFE. If you've had friends or relatives go through the H1B program, the RFE is the dreaded paper that comes from immigration after you've gotten through the lottery, you've gotten your feet in on time, and you get a request for evidence. You can always tell what it is when it comes in the mail at our office because there's a blue sheet on top of it. We can see, oh shoot, it's an RFE. An RFE asks for further information before they're willing to grant an approval. And these are generally the major things that they ask about. They may ask for a percentage breakdown of all the duties that you perform or that you will perform for this H1B position. And it's not good enough to tell the government, well, I do market research and I communicate with, vendors, or I vet out different suppliers of X, Y, and Z. They want to know what that actually entails and how does that work actually apply to what you learned in school. Because remember, the definition of a specialty occupation is an occupation that requires not only the theoretical knowledge of some specialized field, but the practical application of it. Okay, so you have to fight the H1B kind of on both sides of the coin here. You might be able to state, well, these are all the great things I learned at Annenberg, but then you have to put it in the context of your future employer's business. And this really, this whole process really requires a lot of cooperation sometimes from your employer, because some employers don't have job descriptions that go into this detail. Or if they do, sometimes they're more generic, or they may ask you to write it up, okay? And so I've worked with Professor Ben and other professors across the nation to help write explanations from an academic's perspective as to what kind of work the employer is requiring from you, what kind of skill set you bring to the table, and that obviously cannot be gained without going through a bachelor or higher degree program. Because if it could, then it wouldn't even qualify for an H1. If someone could walk onto that job that you're asking for an H1B for with just a couple years of experience or a good portfolio in marketing or an eye for detail or something like that, employers now, their job descriptions are so open sometimes to encompass different people of all different walks of life and different fields of, different majors that they study, that actually harms the H1 petition. Okay, if I were to look on hot jobs right now and look for marketing and communications types jobs, I can bet that there are very few out there that actually require a specific degree. Okay, and I've seen people who have had literature degrees, philosophy degrees, all sorts of degrees go into different, cross sections of the industry. And we're seeing that more and more. Okay, and that's the main thing that you're going to be battling on an H1B if your employer is not specific about what the skill set is. Or if they've not had a hiring pattern, maybe the person who held that job before didn't have a degree like you. Maybe that person had a lot of years of experience. There's something that we can do to kind of argue it and be persuasive about it. So, going on, there are alternatives to H1B. Now that I put a wet blanket on the program, I didn't mean to do that. But I just wanted to be realistic about what you might be asking for from an employer. and of yourselves too. There's exchange visitor visas, there's the Canadian and Mexican free trade visa, and E1, E2, again, visas based on trade and investment. If you're lucky enough to be Australian, you get your own visa category. And then again, the O1, which is for workers who have achieved a level of extraordinary ability, and then religious workers. The TN is very similar to the H1B, okay, as is the E3. And when you get your visa, just know that the embassy will vet you a second time there. They have the right to go through the entire H1 petition and ask about certain things that are specific to what your employer said, specific to even your nationality. If you come from a certain country, there are background checks, sorry, Chinese is in there, especially if you're working in very sensitive areas of the industry that deal with physics, you know, biological weapons, explosives. Maybe that's not going to be what you pursue, but there are all these different restrictions and things that your employer has to be transparent about if they're in a field that deals with these types of sensitive services. So we talked about most of this. There's immigration reform is on the horizon, okay. It's been talked about for many years. We haven't seen a whole lot of progress in the last year. So again, keep your eyes and ears open for something, but something that we hope will happen will be that F1s will be able to, not so much F1s. Oh, eliminate the concept of dual intent for F1 status. F1s are students, as you know, and you know that you are only allowed one real intent, which is to come and study and then leave, right? And then if you study and you go to OPT, you can, you know, intents can change, but F1 is that kind of strange visa where, you know, everyone who comes here to study normally ends up on OPT, mostly ends up on H1B, so why not just eliminate dual intent altogether? And that way you can, you know, not be worried that in a consular interview that an embassy officer may really grill you on whether or not you have a true intent. Because let's say maybe your family is already living here and you're an F1 student and you know you have to go back, but you know, when you have relatives here, that is seen as something that might draw you to continue staying here even after the F1 period's over. So that's kind of mucked up things for people in the past, and so hopefully that might be lifted. Another thing that we look forward to is maybe providing employment authorization for H4 spouses. That would be a boon to H1B holders. If we're lucky, India and China may not have country-specific quotas anymore, okay, and that would mean that people waiting for green cards from those countries would be able to move faster. China and India have wait times of sometimes close to 10 years. And I talked about different opportunities for entrepreneurs, and the administration has been very supportive of it. And there's been talk and proposals about a startup visa for people who want to start their own company. Remember how I said H1B holders generally can't own their own companies? Well, this would allow you to. Okay. So, dealing with an attorney, you know, there are different resources out there to make sure the attorney that you're talking to hasn't been sanctioned, and you can find that on the website. And information about my firm. We're one of the biggest immigration firms in California, definitely in Southern California. We have 20 attorneys, and we handle all types of immigration, from employment-based to investors and entrepreneurs, family-based immigration, deportation, and naturalization. And other than that, I just want to thank you for listening.